Drums, please.
Reincarnated, I'm a stargazer. Life goes on, honey, to all my babies. Looking for the broccoli, keep a horn on me, that could my seat. Keep ownership, the blueprint is by me. Never get off, I get off at my feet. But you nigga couldn't try me in a tri-state. Money pass, but I give him splash. Down south, know me spook town, eyes violated. I got the money and the power, won't gyrate. I look good, get the fuck out my face. Look good, but she don't got no ties. I walked in, walked out with her side.
Okay, can y'all hear me? Hey, Charlene. Hey, Nene. Chantal. I am so sorry that I did not get to come live last night. Um, I had an issue with my computer, as per usual, and I needed a whole bunch of updates on it because I don't cut my laptop on really. So yeah, it's my fault. But anywho's, hey UMD, thank you, Chantal. So I don't have a what the business thing today. However, I do have a video that I want to show that I think this would be Darrell's um, person in the jailhouse. Oh yeah. Y'all remember this one?
You the devil. You the devil. You a Satanist, huh? Then you wrote a book too then, right? You got a book with blood on it, huh? You Satan, huh? Who created your ass, Satan? Who created your ass? I come in the name of Jesus by the power of the Holy Spirit. I come in the name of Jesus by the power of the Holy Spirit. The devil is a motherfucking liar. So you know I ain't worried. Biatch. Stupid bitch. Look at that. I'm provoking that up. I'm making motherfuckers. You see me? I'm all out. I make my ass very available. Tom, next caller. You don't like it? Kiss my ass, you don't like it. It's my house.
Now, do y'all remember? Some of y'all probably don't know, but this is a dude named Reverend X, and he did a show in the 90s. You can tell how old this is, like a public access show in the 90s in California.
What's happening?
Hey, Bazzini. Hey, Dog Mom.
What's happening? Motherfucker, the book I got in my hand. You don't know him? You don't know him? You don't know?
So the caller said it looked like the yellow page was in your hand. And it do. I have never seen a Bible that looked like that.
Look like the yellow page. You're killing me. Next caller. Like I said, I come in the name of Jesus by the power of the Holy Spirit. I ain't playing with your ass. Don't call up and play with me. Next caller, me. I don't give a fuck what you think, bitch. Your thoughts ain't my thoughts. Bitch, I'm flowing straight from the survival scroll. Cut that bitch off. Next caller.
All right, that's enough of that. It ain't nothing to cut that bitch off. Anyway, That's Darrell's jailhouse pastor. So let's go ahead and get into this appeal hearing. Let me get over here. Screen share as I'm doing. Now we was all there to watch this appeals hearing, and you got Basie and the new judge Zach, and you see how rested Judge Jenny is. Her hair is back, nicely coiffed, and she looks so rested now. Looks so rested. So anyway, basically, hey Gina, hey Kayla, welcome everyone. So basically, Dumb Duh-rell, I know we all saw this, we was all there, but for those who missed it, Dumb Duh-rell wants to fire this gentleman here, his attorney. Oh, here we go. This gentleman here, his attorney, so he can do his own appeal. Now, for those of you who have never written or seen an appellate or an appeal, all it is a review. So you're not going to be retrying anything. You're literally going to be going over like the objections and stuff like that, and you're going to verify that there were no material issues wrong with the ruling that Judge Jenny gave. So this is not for the weak, and it's not for the stupid. I wrote an appellate brief one time in law school, and I said, never the hell again. If I practice and somebody wants to talk about some appeal, I ain't the one for you, because it is no joke. Anywho's, let's go ahead and get the party started. Hey, Tammy Lynn.
Or attorney through the Zoom?
What was that?
Are you also able to see your attorney on Zoom? All right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Now you notice the whole time he will have his hand over his mouth. Now I'm fine with that, with him not talking, but yeah. So I'm wondering, did somebody knock out them chiclets in the front, them gray chiclet teeth? I don't know.
Thank you so much. And any objection to appearing remotely today, sir?
No.
And has the state complied with victim rights?
Yes. So I'm wondering, why is he having his mouth? I wonder, did somebody bust him in his fronts in the jail? I wonder. I mean, he has a punchable face, so I'm pretty sure if somebody bust him in the face. Hey, Regina.
As everyone is aware,
hey,
the court is live streaming through the Daycast function of Zoom that CCAP has made available.
Dee, the justice system in this country that's in the toilet. The entire country is in the toilet.
Heard that it is not, please let me know. We are here today to address a motion to withdraw that was filed by attorney.
Getting busted in my shit in the face, that's the business. Yeah, he is wasting time, but I mean, he got plenty of time
Would
to
still
waste.
like you to.
He's got like a millennium of time to waste, so.
Brooks, could you also confirm that for me, that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
He got the forehead. Look, he got the little demon horns right here. Actually, it's like little antennas. So is this his hair, or did he get extensions in prison? Because I mean, this is a lot of hair growth to have no hair.
For purposes of today's hearing, District Attorney Basie, do you agree, or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right, and do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right, do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation.
1,300 years, buddy.
Covey, that would suggest otherwise.
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law.
Now, keep in mind, we're doing a colloquy again. I don't want to like belabor all of this. I really just want to get to him talking.
As well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the
Hey, Daniel.
State
Very
Public
smart
Defender's Office?
Yes, I have.
Are you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order.
He got those roach antennas, because he's a cockroach.
You were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023.
Yes, Judge. I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge, I have spent probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including
I know the hell it was. I know the hell it was, because that's a lot of shit that you got to go through, sir. I know you spent all summer, all fall, all winter reading that mess.
all of the transcripts, the entire court record, the vast majority of the discovery. I'll make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. That we have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes.
Including the box fort. We know you got the box fort.
Before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain. The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the two groups of extensions that I filed over the course of the last year and a half.
A year and a half.
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
So I wonder what is his game? What game is he playing here? So they're gonna extend this out a few extra months for him to do his research in order to review everything. Does he not understand?
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal. As to whether or not there were viable post-conviction or appellate issues, I'm not able to say without breaking privilege.
Hey, Rosebud.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration.
I don't know, Chantal. That's what I'm wondering. Like, what is he going to appeal? You don't know law, because your only law was jury nullification and what else did he used to say? I purge him out of my spirit sometimes. I'm not. Oh my God. Oh, what kind of Brooks or hologram map? I don't remember stuff. Let me just continue. Lord.
Usually it's a two-step process for post-conviction relief. The first part's actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard.
That's what we're looking at now, Dog Mom.
To get me those materials, but that took a few months going through those materials.
So Daquan, he is trying to fire his appellate attorney, which is this guy right here. And he wants to do his own appeal himself. An appeal. Not a new trial, an appeal.
After going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter.
Translation. This gentleman here told this bitch boy, hey, there's nothing here. There's nothing here to for you to have post-conviction relief. There's nothing here. And he said, fuck that shit. I'm gonna do this myself. I'm gonna be pro per. That's what he said. That's what happened. Hey Cassandra, how you doing? Let's see. He was moved to Colorado prisons. Oh, his teeth were knocked out and he was essayed, huh? Oh, ho, 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 ho. Okay, please be careful, dog mom, and if I'm still on the line and everything's okay, just pop back in and be like, hey, I'm okay, just so we'll know. Thank you, Cassandra. I appreciate it. He's in South Dakota. Okay. Hey, Mad Titan. Welcome, welcome. Subject matter jurisdiction. That's correct. Let's continue.
I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately when discussing with Mr. Brooks is to talk about the options. One option could be a no merit situation. So I generally just want to know if all options have been discussed with him at this point.
Absolutely, Judge. That I can say 100% certainty. And multiple times.
Is it your understanding,
hey, Cassandra,
that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency?
Judge, he does want to represent himself moving forward.
Oh, so freaking stupid.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any discussions.
Let me ask it this way.
Yeah.
So I would like Mr. Brooks, and actually, let me state it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. Else I'm in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
22 years. 22 years. Huh.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I have solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Munchkin's right here. Oh, he was. He was right here. I don't know where he went.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Corey Chirafisi for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments.
Now, see, if you notice, Judge Darrell is going over all of these attorneys' qualifications, hopefully saying to Darrell, listen, dumbass, he is qualified to do this. You don't want to do this. You saw what happened last time. It didn't work out for you, did it?
Rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion.
Judge,
yes, thank you guys. Thank you. And thank you for smashing that like button. Whether you come in or out, please and thank you.
Mr. Brooks, in person and over the telephone. I'm going to speak in very, very general terms.
Well, Cassandra, the victims, none of the parties are going to be involved. This is just a review of all of the rulings from the lower case to see if there was any errors and if he has any grounds for any issues, major issues that probably could have affected the outcome, which I'm going to go ahead and say probably, possibly, maybe held to the no. Anyway, let's go.
The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between a post-conviction motion and going straight to the Court of Appeals and why that would occur. That is, as to the details of drafting a brief, rules of citation, the fonts and
see, he's talking about what is needed to do an appellate brief. Let me rewind just a little bit. I'm telling you, it's terrible. Y'all remember that, and I can liken it to like a more detailed, technical research paper. Like if you were in undergrad and you had to write a big paper, and you had to do it in a certain style or a certain size font, and you have rules for your citations. Same thing with this.
That is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that.
And that bitch ain't gonna read a word of it.
Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case, they won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple banker's boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those
Hey,
materials
Anna.
with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make sure I understand this. The prison facility at which
His
Mr.
home.
Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive.
If we set them disk and flash drives.
Look at that ugly bitch. Look at him. I hate him so badly. Oh, look at this ugly bitch.
I'm very confident the prison would accept that.
Hey, Cindy.
But they made it clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily.
Or they can store it in the law library. Because remember, they only have a certain time where they can go to the law library.
Where Mr. Brooks could access it in their library.
See?
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going?
Chantal, someone ran over a parade in Canada? How bad was it? And Chantal, are y'all letting the refugees from America come there? I'm just asking for a friend.
Going to the facility, even with your own computer, and as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program Facility.
And he looking like, I don't know what these freaking white crackers is talking about. When I'm gonna get to talk? When these bitches gonna let me talk? You see, I got all of my boxes. I got a whole box fort. I'm just saying it's a box fort, but they ain't really in there. I don't know what's in there. But I'm supposed to be asleep anyway. I don't even know why they got me out the bed for this bullshit.
In Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that.
Oh, honey, you gonna sponsor me, Chantal? Listen, we may need you, okay? We may need you. Baby, you know his breath is awful. It's awful. That's probably why he's frowning up like this, because he has to smell his breath with his hand over his mouth. So that's what he upset about. I get it now. I understand. And I don't know if y'all have ever been, had the occasion to have, what am I saying? Like your crown came off, or you needed a cavity, and maybe you delayed going to the dentist for a while, and so you have the scent of decay that ain't really that wonderful before you go get your root canal and all that stuff. Imagine the little bit that you have when you have a filling you need, or a root canal. Imagine, that. Then imagine what we dealing with him. Imagine how bad his breath smell. And listen, these two little things, these antennas right here, they are really getting on my nerves. It's really just time to shave our head and just leave it off. This is not gonna work. Locks on the, it's not gonna work. It don't make no sense. It's like you got a bangs here, and then you got the back in like an Al Sharpton little swoop thing going on in the back, the hump. And anyway,
volume of materials to a meeting anyways. Had I desired to go through any piece of audio video evidence, there would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous
them
for me.
Shark eyes. Look at them shark eyes.
You obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him
On the Bucksport.
from his trial to the facility where he is at?
He like, I don't know why they're asking that bullshit. You know that they took my boxes, bitch. You the one that took my boxes.
Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure should this motion be granted?
I have not put in that request yet, but I am certain they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Well, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware
He's like, it's my time to shine. It's time to shine.
that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might, yeah.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advised the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin statute rule section 809.30 sub 4 sub B. I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion.
Look at his head. Look at this. With two antennas in the front. What is this? Ah.
The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks directed attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation and no new or successor public defender attorney will be appointed. Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
No, you don't.
Yes.
Do you have any questions for me about that?
No.
The letter goes on, an indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Hell no.
Yeah.
Do you have any questions for me regarding that?
No.
You need to be asking.
The letter goes on to provide the legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. For your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural
Yes, Cindy. Yes. Yes.
posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being
Allie,
written.
even Ray Charles could see. Michael Jackson, wherever he is, can see this hairline is gone to November.
That's not applicable here. I'm having a over Zoom face-to-face discussion
Hey,
with
Steph.
you. But this is the framework that will
Hey,
guide
Carrie.
the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Oh,
Thank you. Any questions for me thus far?
he was like, Mom, I know about this. Can I tell you? I brought my toy, Miss Darrell. I brought my toy for my book report. But what is it? What y'all do? What did we used to do? Watch and tell, catch and tell, something. I'm old. But anyway, that's how he looking. Chantal, allegedly, he was essayed in the pokey, and he got his teeth knocked out. So
All right. So I just want to confirm, sir, did you ask Attorney Covey to withdraw?
yes.
Yes.
Did he send you a copy of the motion to withdraw?
Yes.
Have you reviewed it?
Yes.
Do you have any questions about
You
it?
need to.
No.
Do you take any issue or claim made by Attorney Covey
Thank
in
you.
dispute?
Thank you, UMD. You're always so helpful and so pleasant.
No.
Did you at any point in time tell Attorney Covey you're fired?
No.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks would ask me, when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great. Thank you. I appreciate that clarification. I still wanted to ask from
Sure.
his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right.
He's like,
Why do you
bitch, why
want-
are you asking me? You know, I know what's going on. I know that you know that I know what's going on. And this bitch here, he won't listen to me. I'm telling him what to do and that we're going to win if I do my presentation. But he was like, no, no. There's nothing here. I'll submit something, but ain't nothing here. Now I want you to argue that I am. I want you to argue the Constitution and the Uniform Commercial Code and what else do they use? And just whatever bullshit I pull off of line. These are legal facts that I need you to run with.
Attorney Covey to withdraw.
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You can definitely answer the judge's questions, but I would just be guarded as to going to the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you, how would you characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
Yes, Valerie. Yes.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying.
What?
Yeah.
So you're prepared to follow the rules and procedure of appellate
This was an
procedure
outline.
and submit
Hold on.
written court. Do you understand that?
Briefly, I understand the outline of what you're saying.
So,
Yeah.
in other words, now I didn't understand a word you just said, but I got to look good. I got to let you know that I control all of this and I know all of this. So, yeah, I ain't got no questions. I got it.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights.
Yes.
Do you have, or what access do you have to legal
Bruh,
research?
You shaking your head to get your two little antennas out your face. Like, dude, come on. Acting like he Johnny Depp or something.
At the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
No.
You've answered it. Thank you.
So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction
I ain't got
motion?
nothing but time. It don't matter. I ain't got nothing but time.
Yeah, I do understand that. I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say.
Listen, when this trial was going on, and I think she just says he's in South Dakota. I'm telling you, within 5 minutes, his whole location was thrown in the chat multiple times. He got doxxed in real time. How do you get doxxed in prison?
Judge, I can verify that he is no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second because we take a brief segue.
Sure.
I'm treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I am a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses.
That's it. And that was all it took. It was South Dakota. That's all it took. Whole prison location dropped live. It was
For
great.
individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
So basically, Judge Darrell just had her Karen moment. And she basically said, I got terrible customer service and I need to talk to the manager. Hey, block party. Yes, he has a big forehead and there's nothing in it.
Thank you,
There's
Judge.
nothing in it.
Mr. Brooks, do you believe that despite some of the challenges that you've described, or at least stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But
Then why the hell are you doing it then if it's going to be difficult? Why are you doing it? What will you gain from this? Are you want to argue about charge 77 and the day before the parade when you tried to run Erica over? Are we doing that? Is that what you're trying to add to this? I'm pretty sure it is. This is ridiculous. Oh, it's difficult. Yeah, it's very difficult. Yeah, very.
do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was
What?
based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
What?
I understand what you're saying.
That's
I'm
irrelevant.
aware, but
It's relevant.
do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? Do you understand that?
Yes.
All right. And again,
Because it worked so well for you the last time. It worked so well for you the last time. Instead of you getting 6 life sentences, you got 6 millennia.
and I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody
Forever.
further complicated by the fact that you're serving those out of state and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
Ask some.
As you know, Attorney Covey was appointed by the State Public Defender's Office, meaning at the government's expense,
Ugh.
to investigate and review your appellate options, and that the Public Defender's Office through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that?
Hey, Sasha.
You want me to restate that?
No, I said yes.
Oh, I'm sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
No.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal.
Take it.
And includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
No.
Yes.
No.
Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to.
Or it could be a classroom. It looks like it's a this is the class back in high school that the coach study hall, free period. This is his classroom.
Also does not include the right to insist that your appellate attorney pursue issues which
I'm sorry. Good for you, Chantal.
He in his professional judgment choose not to advance. Do you understand that?
Yes.
Yes. Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes, and to be clear, there was no disputes between me and Attorney Kobe. So there was no strategy disputes. There was nothing of the sort.
Wonderful.
Sir, I know from presiding over a previous hearing
Good. I'm glad you're okay.
related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Oh, that's a little thing that you put a thing over your mouth and it looks like the person is just talking in a walkie-talkie type thing. Now, look, do you read, write, and understand English?
Yes.
Right.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you.
Okay, high school equivalency. So this is yet another lie because he said that he had a HSED. He said that he got up to the 10th grade. Oh, what are some other lies he told about his background? I think he graduated high school was one of the lies too. So he's all over the place.
Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
All right. Do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
Well, that's not true because you're breathing in your face. So it's like having nitrous. And it's, I wouldn't say it's intoxicating, but it leaves a very strong effect that will, make you a little bit slower and, like you're high. It's that, yeah, you got your natural juices going.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
An epic fail.
Is there anything about this court hearing thus far that you have not understood?
No.
But look, if they do get a chance to go and have an appellate hearing, and that would be hilarical if that was recorded. One of the things that he's gonna say is, "I didn't understand. I didn't know. I didn't understand." Hey, you had the opportunity to ask whatever you want to ask. All of these questions that has bubbled up in your mind from 2 years ago, those are questions so you can understand.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Lies.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template. And I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is, for my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
Right.
You understand he's not required to do that. He's just offering to do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not.
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just understanding should be there that, again, this
Here we go.
facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record.
For the record, he is the floor's bitch, and he's got a lot of assuming the positions that he has to do. He don't have time. He don't know how much time he's going to have in a day because, yeah, he's the yard bitch. Yeah. Been spreading them cheeks wide open.
That it's just a lot different, and there's a lot of
bubbling.
different procedure wise things here. So I'm still navigating that as I haven't been here that long, so I'm still learning as I go.
Who the fuck cares? Okay, who cares? Oh, it's an adjustment period. One prison to the next is different. Who cares? Whatever it is, you're not going anywhere. Sometimes it's so different. Like you're going from elementary school to graduate school. Yeah, that's really different. It's so different. Going from Dodge prison to whatever prison in South Dakota. This is stupid.
So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Colby, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
What?
Attorney Covey, it's my understanding, based on what you've said, I mean, you believe the institution will accept the external hard drive
that again
through regular mail, just not banker boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet
oh my gosh,
of
I went back too
material
far. Hold on.
to go to a computer library to review your legal documents, I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just going to say that too. There's no law library, which I've never seen a jail or a prison without a law library. So I don't know how that's going to work.
Do you have access to anything through a computer or online to access research material?
I have access to look at, I believe it's Westlaw.
Westlaw, the law library. Freaking idiot. The law library.
Those are tablet
Yes.
based.
Them shits you should have been reading the last time, because you have documents and paperwork and your law library. You said it was a tablet. So yes, it's like, oh my God, I can't, sweet baby Yoda, I can't.
But even that is challenging.
I use a tablet-based Lexis. It's a similar platform. It can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at.
No, Mom, I read it in his voice. Remove it in.
But I think it's similar to what you had when you were in Waukesha. Is that not?
No, Waukesha had Nexus, Lexus, or however you say it, Lexus, Nexus, or
They're very similar. If you figured out Lexus, you can figure out Westlaw. In my humble opinion.
Judge, if I may add one thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. Mr. Attorney Basie, is there anything the state wants me to consider or any additional information from the state today?
They got it.
All right, then, as I indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a criminal conviction. And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the U.S. Supreme Court and Douglas versus California, 372 U.S. 353 from 1963. There's no dispute here today that Mr. Brooks is indigent. This court has noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waives the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4.
That was in that book you didn't read.
As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Oman versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case,
Sasha, this would be the prime person to send to El Salvador. Now, if they need the ICE need to get anybody, it's him, and get him to CCOT immediately. That's the one that needs to go for real.
The Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist's rights, which I've talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26 of 2025. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022.
Hey, Tyrone.
I just want to, I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through 7. The court makes some findings that I believe are confirmed here today, and that's, he said today he had a GED that may have been referenced as an HSED. I think they're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that efficiently and effectively. He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And so I'm just going to rely and incorporate herein by reference many of the findings, or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise, that he's intelligent, he understands the dangers and disadvantages of proceeding on his own. He's made the request. He now knows the SPD's position. He indicated it doesn't change his mind. We've discussed many of the disadvantages and potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Covey to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so, again, freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Covey's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Covey, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
You done fucked up now, Mr. Postman.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Covey?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials, that I can file a letter with the court saying that we have done so, make a record of that, and then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess you can sign the order at any time. I don't, and oftentimes I'm kept on the e-filing system even after I've been withdrawn. It's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out. I'm not trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast and we want to make sure everyone gets there.
Thank you.
Till the end. Thank you, everyone.
Serial killer.
Good luck to you, Mr. Brooks.
Thank you.
Good luck, sir.
Osama bin Laden. Okay, hold on, let me get this up in here. Yeah. Oh, there we go. I heard what the hell you said. Oh God. Oh, the Darrellisms were great. I mean, I was reading it in his voice. Kiki Ken. Y'all he and Kiki Ken. No, I do not agree to an estoppel. Is that a tacit agreement? Oh man. Yeah. I had cut my baby's umbilical cord out the womb. Yeah, I accept for value, return for value. This document, my license place. Am I muted? Am I muted? Oh Lord. Oh yeah, the cage bird. The cage bird. Yeah. Oh, let's see. All right. Well, we did the hearing. So like I said, it's gonna be a hot mess because it's really complicated and complex and technical to write an appellate brief. It is awful. And I doubt seriously that they actually get to a hearing. It's probably going to be they submit the brief and it's going to be automatically denied. Automatically. So y'all make sure that you guys smash that like button. And I am going to do a quick intermission.
Walk. Come on. Yeah, nigga, what a surprise. Did something that nigga close with your eyes. All my niggas getting money, capitalize. Die, little small guy, we on the rise. Everything a nigga touch, platinumized, fully equipped. The Cold B is now live.
And you took this as a shortcut. Cause you 9 and you 10 and you don't want to around the block on Prospect cause that's where you live and mama's hanging out the window crying.
Oh Lord, what I do? Hold on, let me escape. Okay, I'm trying to do that. I'm trying to make me. Okay, what's happening? Okay, there we go. All right. So before we go, it is time for our Black History lesson. And for those of y'all who are going to leave now that I've said that, thank you for coming so much. Again, make sure you smash the like button on your way out. Okay, what screen am I on? I am so lost. Okay, here we go. Here we go. Here we go. Lord, I don't know. Okay, anyway, this is about the unethical and racist medical practices. All right, so this picture that you see here, this is a enslaved woman named Anarcha. Okay, so J. Marion Sims. These are all people from Alabama, of course. You know, Alabama got to Alabama. So J. Marion Sims is the father of modern gynecology, and he experimented on these gynecological procedures on enslaved women. So this is back in the 1840s. And so Sims developed a treatment for fistulas. And so he experimented on enslaved women for years and years. So he conducted surgery on a number of women, but there are only 3 that we know about. And that is the names up here: Anarcha, Lucy, and Betsy. These women had a value to the slaveholders for production and reproduction. So basically, how much work that they could physically do and how many enslaved children could they produce. So by having these fistulas, the women would not be able to, they would have difficulty working, and then they would have issues with, childbirth. So the surgeries, which were repeated over and over on the same women, about 30 times on Anarcha, and those were especially painful. Those were done without anesthesia. So Sims wrote in his autobiography about Lucy, saying that Lucy's agony was extreme. She was much prostrated, and I thought she was going to die. After she recovered from the effects of this unfortunate experiment, I put her on a table to examine. Modern critics note that these experiments were conducted without anesthesia, and after they perfected the technique on Black women without the anesthesia, Sims would then offer it to the white women, but they would have anesthesia. So in modern day contemporary medical practice, Black patients continue to receive less pain medication for broken bones and cancer. Black children receive less pain meds than white children, like for things like appendicitis. And many people erroneously believe that Black people have literally thicker skin than white people and that we experience less pain. And we've heard some members of this administration echo those same eugenicist sentiments. So then another, the unethical practices in cervical cancer and HPV research. So in 1951, it was a Black woman named Henrietta Lacks. She died with an aggressive form of cervical cancer while in treatment. Samples of her cancerous tissue were given to researchers without her knowledge or consent. It was later determined that these cells were unusually durable and had the capacity to reproduce prolifically, rendering them quote unquote immortal. So the cell line known as HeLa cells, was distributed widely to scientists and researchers. So these cells have been fundamental in making discoveries in the field of polio eradication, virology, cancer and genetics, and many others. So these cells were sold for profit by biotech companies and led to many profitable discoveries. The Lax family received no financial reimbursement and was not acknowledged by the National Institute of Health until 2012. So again, she died in 1951, and they didn't get any acknowledgement until 2012. Lax medical records and cell genomes were repeatedly published without consent of her family. Lax cells continue to be used. Lax cells continue to be used globally for medical research based on an agreement with her family and NIH. And this information might be deleted from NIH because it's technically DEI. Anyway, Lax cells were used to discover the connection between HPV and cervical cancer. So this is just echoes this racial disparities in reproductive health care. It still remains prevalent to this day. Black women are 5 times more likely to die during or shortly after pregnancy than white women, and non-white women are less likely to receive pain meds during and after childbirth. So anyway, you said with that, yeah, absolutely, it was sadistic. But you know, when you don't see a human being as a human being, this is the type of stuff that you get: man's inhumanity to man, and it keeps us in perpetual darkness. I wrote a paper about that, by the way. Hey, Holly's mom. But the guy that did the gynecology, all of those like medieval torture devices they use, he's the one that developed that. The speculum, the thing they stick up there, the coal stuff, all of that, the thing that they used to pry you open, him. Hey, Sheree. So yeah, that's him. So as you see, they be using the exact same shit that this asshole developed. That shows you how far behind we are on women's bodies and gynecology and all that stuff. So anyway, oh, half my folks left. That's all right. I hope that y'all will red ball it back and hear the Black History. I'm gonna start putting a time stamp. So for those who just want to skip it or whatever, I'm gonna start doing that. Because I know everybody don't want to hear this, but it's important to learn and not to say anything to make anybody feel bad, but history is history, and all history, the full picture needs to be given. And it's also to say all of this just awful stuff have happened to a particular group of people for no reason other than the level of melanin in their skin. And despite all of that, and Jim Crow, and erasure, and misogynoir, all of that stuff that we get, through all of that, laws, being lynched, beaten, disappeared, all of that, and despite of, we have progressed and progressed and progressed. So, anywho's, I want to thank you all for coming this evening and spending time with me. And I promise I'm going to come back soon, sooner rather than later. I'm trying to share this. Yeah, stop. Okay, there we go. Yeah. And I just want to thank everybody for coming and spending time with me this evening. I'm going to come back and do some more. Y'all, I tried to watch the Lori Vallow when she was representing herself, but it was not giving me what I needed it to give. I did not have a ooh-ah sensation watching that trial. And then the breaks, they had more breaks than YSL. So the breaks, the start times, and I just wasn't. It didn't give me what I needed it to give. There was no. She didn't like snap out, but I will say, I wonder why was she now? She's already convicted prisoner. Why is she allowed to walk around the courtroom? But Dusty Darrell was chained to the table with a shock device. Oh, it was boring, Chantal. It was boring. Lori Vallow was boring. Now, I mean, she did have a few of her Karen moments that came out, and when she cross-examined the mistress, that was entertaining. You know, if you didn't come by and tell me that you liked my grilled chicken enchiladas or chicken fajitas, whatever she said, I'm just like, oh, I see what's going on here. You still trying to beat that you kill. You still trying to say, bitch, that's my property. That's right. That's my property. I see, yeah, she's a woman. Yeah. Huh? Oh, yeah. Different judge. But you could tell that guy, he was so patient, but he was getting so sick of her. And Laura's making all those little comments. And she has that really sweet, you know, my name is Lori Vallow, and I'm just a wonderful Christian woman. I wouldn't hurt a fly. I'm really nice. I bake cookies. She had that type of voice. It was fake. And I know she's a Mormon, so that's probably that part of their keep sweet thing. You know, women have to, you know, dress like prairie women, and just walk around with hair down to your ankles and having a bunch of children. And being a bunch of wives, and getting married at 12. And I'm talking about not the regular Mormons. I'm talking about the fundamentalist Mormons. I'm talking about what's that weirdo's name? Who the leader of the FDLS? The green chicken chili enchiladas. Yes. Oh man. Yeah. And you saw my husband, and so you don't remember the green chicken chili enchiladas? You didn't say that you loved my green chicken chili enchiladas. You didn't love those. You didn't ask me for the recipe for those green chicken chili enchiladas. No. Warren Jeffs. She's one of those Warren. No, I'm talking about the Warren Jeff people that wear the pilgrim clothes. And you have an old man that marries 12-year-olds and sisters and mothers and daughters. It's just ew. Yes, Warren Jeffs. Oh, I may resurrect my cult series and maybe hit some Keep Sweet and maybe play some of his you know, Warren Jeffs sings and they listen to his stuff. Yes, don't flatter yourself. That was great. That was a messy day, and that's my type of mess. The Lori and the ex-girlfriend, the mistress, that's my type of mess. I was with it. And after those fireworks, it just went there, it fizzled. It died. And I wasn't happy. I was really looking for that ooh-ah sensation. Yeah, straight off the Mayflower. That's some folks straight off the Mayflower. I mean, I think the Mayflower people was better. I mean, they got those. Y'all remember the old time Sears catalog? And back in the early, back in the day, that style did sort of make a way back. The little prairie dresses, of course, they was a little bit shorter and there was different material. Those prairie dresses had folks in the 80s and 90s in a chokehold. Then they became like skater dresses, but it's bad. It was bad. But yeah, I think I like the whole keep sweet thing. The FLDS are some interesting people. Donna Adelson. I'm going to tell y'all the truth. No trial had the fireworks that this one had. And it's like you're comparing. It's like, my best analogy is one of my favorite all-time favorite movies I could watch every day, all day on repeat is Scarface. Scarface to me is the pinnacle of camp. It's funny. It's hilarical. I love Tony Montana playing the Cuban and he's Italian, and the whole all I have in this life is my balls and my word. I don't break them for nobody. I love when they push the dude out the helicopter and he's hovering up there and he flies away and then he's dangling behind him. I love Scarface. So what if we do the 2025 version of Scarface, starring Justin Bieber? Why? If Lion King, the animated cartoon, was freaking awesome and it made me cry, it made my shriveled up cold heart cry, the cartoon, why do we need to do a live action one when we already had it perfect here? I don't need to see CGI lions running around talking. Oh, Lord. I know every movie is not Scarface or The Godfather. Oh, God. And The Godfather 2. One of my favorite lines is, don't you know me? Don't you know me? Don't you know I would never, ever allow that to happen? Don't you know I would do everything in my power to keep you from, from happening? He's like, it's okay. You'll feel different. Okay. You'll change your mind. Okay. Go take the kids. And and we're gonna leave tomorrow. Okay. Oh my God, I love it. We don't need to do Godfather 3. You feel me? We don't need a Godfather 3. When we got Godfather and Godfather 2, we don't need 3. I want to hear all about the sexy parties. I want to hear about all of the sexy parties, who was at the sexy parties, who was drugged at the sexy parties, why y'all needed to have marathon sessions. Were y'all enjoying any butt play in the sexy parties? Were there multiple people playing butt play in the sexy parties? Where'd y'all get the hookers from to attend the sexy parties? How much baby oil was dispersed in them sexy parties. How you have 1,000 Jody areas? Good God. Yes. I need to come back to Jody because I mean it's great. But I would only start with Jody when she gets on the stand. All the other stuff, it's not any thrills and chills. So I might do that. I see Carrie's caricatures is doing it. I don't want to make it seem like I'm copying that she's doing it. But I've been said I want to do some more Jodi Arias, and that's one of my faves. Oh, and Suitcase Sarah. Mm-hmm. Yeah. I wish that she got on the stand. I really wished that she testified. I was really hoping. I knew she wouldn't, but I was really hoping she would. I was really hoping that she would actually represent herself and they just let her go. Let her rock out with her cock out. I was hoping that was going to happen. And I was very disappointed that she went, err on the side of caution and got an attorney, so she wouldn't piss off the jury any more than she already did and talk herself into the electric chair. Yes, the third Godfather movie does not exist. It doesn't exist. It is absolute trash. It is trash. It's one of the worst movies I've ever seen in my life. And I have been able to go back and I'll watch a horrible movie. And then I'll be like, you know what? I want to revisit it to see if it's as bad as I remember. Like a prime movie was Alexander. I was so jazzed for Alexander. I said, okay, we got Oliver Stone. Okay, we got Angelina Jolie, Colin Farrell, Anthony Hopkins. Oh, hot dog, this is going to be something special. I'm here for it. Alexander, yes. And then we get in there and it's some foolishness. It's some freaking foolishness. Angelina Jolie is Colin Farrell's mama. They the same age practically in real life, even though Angelina looked her same freaking age. She looked 30-something. Colin Farrell is 30-something. And you calling her mama. And she's speaking in some Russian male bride accent. I thought y'all were Greek or Macedonian. I thought y'all wouldn't Russian male bride sounding 90-Day Fiance folks. Hey, you're my son, Alexander. You're my son. And the Zeus, he took me and he conceived me on the top of Mount Olympus or some shit she said. I can't remember. It was awful. I have not been able to go and give that the benefit of the doubt. I'll catch it in certain sections if I see it, like if it's being streamed somewhere. But as far as just sitting for 3 hours or 3.5 hours, I still remember the 3.5 hours I spent when it came out. And the money I spent to see that shit. 3.5 hours for that shit. 3.5 hours for some mess that didn't make sense. It didn't make no sense at all. But I will say Jared Leto was still handsome. Even though he had on eyeliner, but he's still sexy. I mean, he looks pretty much the same from my so-called life back in the 90s. Yeah, it was the 90s. Yeah, because I was in high school and they were trying to save it. They were like, we need to call and petition MTV to save my so-called life. We love my so-called life. And they kept playing with our emotion, like, yeah, we're gonna do a season 10. We're not gonna do a season. Claire Danes don't want to come back. That was great though. Chantal, I have not followed the channels to read her letters. I'm sure they are hilarical. Yes, Michelle, I am planning on going live again soon. You know, life be lifing sometimes. So if you ever notice, I schedule a stream and then I move it, usually something has happened. I got stuck in traffic, or I've eaten something and my stomach is saying, you need to stick close to your office. Or Munchkin is, I thought he was in here, or Munchkin is carrying on being Munchkin. And he got me the cutest, he got me a cute Mother's Day gift. He got me a shirt that says that I'm the best dog mom ever. Isn't that sweet? Huh? Are you seeing? Oh, he does? So when you say big, are we talking like Idris Elba size? Because he's got a nice imprint. He got a nice imprint. But you know, hate who? Who we hate? Who we hating? We hate Darrell. That's a given. Who we hating? It's a lot of hate to go around. Oh, I know an example of me revisiting a movie. Okay, so back in the 90s, well, 90s and 2000s, The Matrix, the first Matrix, that movie had our whole consciousness. We was all like, yes, I relate to this shit. Yes, we're in the Matrix. I feel it, especially if you work in a corporate job and you're in like a little half cube and the walls all, pasty, pale, nothing. And, you feel that when Thomas Anderson was in the office and the little cute Nokia phone that we thought was so cool back then. But anyway, love The Matrix. The Matrix is a perfect movie. Perfect. And it ended perfectly. You had Neo was the one. He flies off, does a Superman thing. Bam. That's all we needed. But we made too much money. So we had to come and do Reloaded and Revolutions. So when I saw Reloaded was, I rationalized Reloaded. I rationalized why it did not give me that ooh-ah sensation was because I'm aware now that they're going to do a trilogy. Because Jada Pinkett Smith was all over giving interviews talking about this movie and how profound this movie is and her role in this movie. And she on the screen for 10 minutes and we didn't need her to be there. But anyway, so it didn't give me that ooh-ah sensation, but I said, okay, this is the middle of the story. And so, you had to watch the first one and I'm there, I get it. And the second one, we're gonna have a banger conclusion. I feel it. We're gonna have a great conclusion because it can't go nowhere but up. right? And my issue with Reloaded, what pissed me off so badly, was the love story. Yes, I am a proud Gen Xer. I'm a baby Gen Xer though. So I'm actually close to a millennial. I'm a technically, they call it a zennial. I didn't even know that until somebody told me. So I'm kind of close to an old millennial. But I'm Gen X though. I'm Gen X baby. But I said, oh, Serenity. Serenity pissed me off so badly. She was so, not Serenity, Trinity. I'm thinking about carbonation, folks. Trinity. Trinity was so strong and powerful, but also feminine in the first one. She had a great balance. She was badass, running up the wall and shooting people, and she was such an integral part of the story. Then we get to Reloaded, and it's freaking, we kissing, we have to, sneak away so we can have some freaky sneaky while they dancing in the cave. All these speeches and proclamations and declarations of love. And then Serenity only goes in the Matrix because Neo is in danger, even though she promised to stay out the Matrix. And then she dies, and then Neo brings her back to life, straight up God mode, brings her back to life, and they hug and kiss again. Oh, that angered me. She was such a perfect balance. I didn't get the toy maker, the key maker, the key maker and the Merovingians, and the twins. I actually did like the twins. I thought they were cute. I thought it was a good concept, even though that's gone. I didn't get the little French guy. I didn't get it, but I didn't get it. I did like the little fight with all the mini-me's. Smith is always my favorite, and anything with Smith, I root for the bad guy. So anything for the bad guy to get an upper hand, I'm there for. So I was all for Smith taking over the Matrix. Love it, love it, love it. I even like the fact that he, got on the phone and he was in the real world. I even like where they were going with that. But again, like I said, I rationalized it. So then we get to Revolutions. There is nothing redeemable in that movie. There is nothing redeemable. The climactic battle in Zion is the dumbest logical shit I've ever seen. If you said in the first movie, the only weapon we have against the machines are EMPs, but you're shooting them with bullets. You have these ATV things with guns that have to be manually loaded to fight homicidal machines. Huh? So then why don't y'all use EMPs? Oh, because your stuff, it'll fry your equipment, the EMPs. Why? Why would you? The only thing that can save you will kill you. Who thought this up? Why was I need to be in these rooms and raise my hand and say this does not make logical sense. If the one If the one thing will kill them, you don't use. I don't get it. It was terrible. And then you got to go in the machine, then where we had to manually go and open up the gate to let Morpheus and them in. And then Trinity and Neo go to the machine city. And then they go. The ending, did he become one with the force? Like, I didn't get the halo of gold. Was he going to heaven? What are we doing? I assume that it's heaven or heaven-like. The force, I don't know. The next, I don't know. But it really just irked my nerves. And then the Oracle. Now I know that the Oracle that played in the first two, I can't remember her name, but I know she passed. So you got to make do with what you got. So they had she was I don't even know. But anyway, they got the other lady. I think she was on it's on some show. I don't know, but anyway, but you don't incorporate that in the story. Y'all could have gone anywhere with that, and you should have incorporated. She did mention that I've changed my shape or we made choices, but it should have been a better reason than what we got. We could have had less kissing and more about why the Oracle looked the way she looked and why is she talking in code. Of course, at the end, I get it. The CGI with the fight with Smith and Neo was awful. It was awful, 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 awful. It was so freaking bad. And then it ends with everything that has a beginning has an end, Neo. Oh, yeah. Gloria Foster. So it was terrible. I did not like it. I did not love it. But as time has gone by, I have been able to appreciate certain things in each movie that makes it not the dumpster fire that it was when I saw it the first time. I've developed a better appreciation for those two. Now, if on a marathon comes on and they have one, I'm there. Two, I'll still be there, but I'll probably start taking my my sleep medicine, and then I'll be going by Revolutions. So that's my rant, I guess, for the evening. I hope I helped somebody understand there's something that's shitty in 1995, but it could be. Oh, I got a good one. I have a good one. I don't know how many people have seen Office Space. I saw Office Space when it came out. I did not understand it because I was still in undergrad. I did not understand any of that at all. I said, this movie is terrible. The only reason why I watched it was because it was written by the people who did King of the Hill and Beavis and Butthead. That's the only reason why I watched it. So I didn't understand any of the people they work with, the corporate environment. I didn't get it. Fast forward to I graduated from college and I'm in my second year law school. I get my first real corporate job after getting a degree. So that's a very rude awakening when you graduate, because you think back in the day, like, yeah, when I graduate, I'm just gonna get a job, like entry level job, but and I'll just say like a reasonable salary would be like $45,000, and this was back in 2000 ish, pre 9/11. Um, Hold on, I lost my train of thought. Oh, so then I get there, and it's this big corporation, and I'm a database editor, and I'm there with a bunch of stupid, ignorant, retarded bitches, middle-aged bitches, myself, another girl, and so my friends was Dana and Jessica. And so Jessica was sort of like the little goth. She was really, really pale, like really pale. And then she had black hair. And then I think she had like some little red streaks in it. And so she was real tall. We used to call her Morticia, but she's our goth girl. And so Dana, she is my white twin. We were the same person. I have never met a person that is exactly like me, 100%. Same sense of humor, same everything. That was my girl. And so we used to call ourselves the Spice Girls. And I was Mean Spice, and Jessica was goth, Wiccan goth Spice, and then just Dana was Old Spice, because she was in her 30s, so she was old back then. I think she was like 34. But these other women, they were the most petty, ignorant hoes ever. And so, like the girl in the Office Space movie, she's like, "Thank you for calling Tech speaking. Yes, man. Thank you for calling. Thank you for calling Tech." There was one who was like that in the department. And again, it's a half cube, so there's no privacy. So there was one like that. The supervisor coming by, "Hey, what's happening? Did you take care of ABCD?" "Well, no, I didn't get a chance to." "Well, yeah, so we're going to go ahead and get you to go ahead and take care of ABCD. Did you see that email that we sent out about ABCD?" "Oh, yeah, I was checking it and I got sidetracked doing something else. I must have missed it, but I'll pull it up. I got it pulled up right here." "Well, I'm gonna just go ahead and I'm gonna go ahead and send you that email again. Also, please make sure that your music and your headphones are not too loud, and that you are not saying anything to anybody other than good morning or good afternoon." That's a real conversation, by the way. Or you know how Elmo had those people do the 5 things. What did you do? 5 things for the week. So we had to do our metrics and send our metrics to our supervisor every Friday, I believe, like clockwork. So I'm sending my supervisor questions about something. Email is not being got a delivery and a read, because when you're dealing with trifling petty bitches, you got to cover yourself. So I used to get my delivery and my read. So I remember one day I was sending my metrics, and then I sent an email to Dana about something. Maybe it was about food. I don't remember. I would send her an email. I get a delivery and a read receipt from my manager. Shirley. That's what we call her, Shirley. So, yeah. So we got delivery and a read from Shirley. This is the email I sent to Dana. I'm getting the read, delivery, and the read from the supervisor because she's so freaking stupid that she doesn't know that whatever she had IT do, that we're getting deliveries and reads from you, all of us. And we're talking about it like, you see this shit here? Like, we actually doing some work, and the supervisor and her head crony, the assistant manager, the head crony, and then I think maybe the director's assistant and the director. They was all in Shirley's office because the office was glass so she could watch us. So her office is glass so we can see her. They're all standing there reading emails that people sent Dana, and we know that they're doing it. We started sending all these crazy emails to Dana. Her ex-husband, that they met there, and he worked in the IT department. Our department and IT department, we could not be friends. It was going to be a problem if you're friends with people in other departments. I don't know why, but it's a problem. But that prompted Dana being surveilled. So they're reading all of these emails all day long. Shirley got a project on her desk that she had on her desk for 2 weeks. She busy reading emails that we sent to Dana, and then she tries to give it to us 2 days before it's due. Do you think anybody worked on it? Nope. We said it couldn't be done. Oh, we'll pretend to do it, but yeah, we're not really doing it because you've been playing games. So I was saying, Dana, like, here's a narrative you can put in the thing for Spy magazine, and here's the number to access Spy magazine. And then her boyfriend sent Dana a password protected email. So we were all like, that's what we're going to do. We're just going to send Dana just all type of just stupid shit all day long. If she's going to read, she's going to read today. She's going to read today. And you know what? She learned her lesson. We wore her out. Where I worked at, I had, we got 2 5-minute personal calls a day. 2 5-minute calls. So, say my mother calls me about nothing, but we only stay on the phone for 2 minutes. I'm thinking I got 3 minutes that I can add to the additional 5 that I have. So I can talk on this next call for 8 minutes because I've already only talked 3. Well, no. They meant literally 2 5-minute calls. So if my mother calls me to say, hey, can you remember to get some eggs when you get off? Okay. And then I said, no, you can't get off the phone. Well, I didn't want anything. I said, it doesn't matter. I have to be on the phone with you for 5 minutes. So, yeah, I have to be on the phone with you for 5 minutes. So if you call me about nothing, 5 minutes, we're going to have to talk. They sent me an email. They sent me an email one day, and they told me that sometimes it seems like I hang up the phone too hard. That was literally the email that I received, that I hang up the phone too hard. And so Dana, smart ass, she went and she got some tissue and she put it to make a little pillow on my phone. And then she put a sticky note on the phone and she says, like, please be gentle, sign the phone. I decorated my desk with some little Care Bears, and then I made little picket signs. I had little toothpicks and I made little picket signs. It was like unfair treatment, union now. And so they were like, yeah, I think that's inappropriate. You need to take those down. And so I was there for 10 long, agonizing months. And every character from Office Space, I literally worked with. Every conversation I had, there was a Milton guy, a type person that's, crazy off in the corner, mumbling to themselves. There was one of them. Just all the crazy people, the lackluster birthdays, the happy birthday. Yeah. Or the what can we do for the company? Those meetings. And is there anything that anybody wants to say? No. Because whatever I say will be used against me in the future. And we're going to have another meeting about it. No. I'm just here. Don't ask me no questions. So the happiest day of my life was when I got laid off. And Dana and I got laid off at the same time. See, I had a feeling in my spirit there was some shenanigans going on. So we were getting our department worked on. So we had to rotate to another department. So strange things were occurring. And one day, my emails were open and read. And I thought that was strange. But again, I felt in my spirit it was some fuckery afoot. I felt it in my spirit. So before we did our little desk transitions and stuff, I took all of my decor, like my little Care Bears and anything cutesy, I took all of that home. All that was on my desk was my stapler, my tray, my name badge, and that was it. I took everything home, gone. I think I may have had a CD. It was just stuff I could just grab. Anytime they say you can go, let me just grab my phone, my keys, and I'm out. You can have whatever else is there. So we had no personal stuff at our desk anyway. So they called Dana and I in the office. So I'm thinking to myself, oh, well, it may not be too bad then. Like we must have said something. It's one of these meetings. So Shirley goes and tells us about, that we're doing restructuring and they are determining that we need to cut back on payroll. And so they're eliminating the special projects team. So this is going to be, your last day. And then we have, any questions you want to ask. Blah, 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 blah. So Dana and I looked at each other and she just says, do you want to get lunch? And I was like, absolutely. Let's go. So this was the time before you got escorted out by security and, all that stuff. So they let us get our stuff. And they was like, oh, we got some boxes right here. Hey, Tony. Yes, the red stapler. So they were like, we have some boxes. Because I noticed there were boxes by the door, but I thought it was because of the move. I didn't pay any attention. Well, those boxes were intended for us to pack up our stuff. And we was like, no, I don't need it. I don't have anything here. I can just go. So, I told the few people, Jessica and one of the other ladies there, a few other ladies that didn't annoy us, that we were leaving, gave them a hug. And then I went downstairs to see my friend who worked in IT. We would go hang out at his desk when we needed a break from the foolishness. So I'm just like, hey, yeah, we just got laid off. So we're getting ready to go to Moe's up the street. So if you want to come, you know, you're not on a leash like we were. So yeah, we're going to have lunch. And so we were like there was no tears, no upset, no questions. You know, they said we was gonna get severance. So I was like, okay, wonderful. I hated this job anyway. Hey, what the hell ever. Okay, I still live at home, whatever. Like I used to cry when I got to the parking lot. I would be in tears. I hated that job that much. I hated it that much. It was torture. And they were talking about the stupidest stuff. Anytime we had an email about food, like so-and-so brought some food and it's going to be at so-and-so's desk. It was a stampede going to the desk. So, you know, Dana and I, you know, we worked out and we were, you know, healthy eaters, and we bring our carrots and yogurt and stuff. Well, we got told that we could not have anything at our desk that we could not suck through a straw, because there are nasty people there who have snacks and snacks and snacks that is at your desk. You have a drawer full of snacks, and there have been rodents because of these snacks, and they still have the snacks. But I had to not be able to use a spoon to eat my yogurt, but Dewana could go and eat a bag of pork rinds. No lie. Oh, I'm having a moment. I'm going back in time. I'm having a moment. This was torture. So, but again, other people were eating at their desk. You could have popcorn or Yo Play. Like, which one is worse? Which one? You're going to get critters from the popcorn kernels and the crumbs on the floor. You're not going to catch rodents with yogurt. We had a 30-minute lunch and we had to clock out. So we had cafeteria though. So we had 30-minute lunch. If I wanted to have soup, can't eat it at my desk unless it's one of those Campbell's soups, the drinkable soups with the little lid. I don't even know if they still make those. The cup of soups. I can do that. But anything with a spoon, I can't have. I can't have. Because you have to eat it with a spoon. These hoes told us that we can, if we have any personal calls, they gave us a report of our phone calls. You need to highlight any personal calls that's over the 5-minute, the 2 5-minute rule. And we had to have a meeting about the report. And that's how I found out that you're not using the whole 10 minutes. Like if I'm on the phone with one call and it's 10 minutes, and that will qualify as part of the 10 minutes. I thought that the focus was on the 10 minutes, not on the number of calls and the 10 minutes or 5 minutes per call. I didn't know. It didn't make sense to me, and it still does not make sense to me. There was meetings being called because somebody told that somebody passed gas. There was meetings called because somebody heard that somebody said that they was all fat. No joke. No joke. Was a CD? Yeah, I know that was a long time ago. But yeah, yeah. It had got so bad, right? They had put me on. My doctor gave me some Lortab. No, not Lortab. Xanax. Gave me some Xanax. Cause I was just like, I'm just having a tough time. Just give me can I have just a little something to keep me calm? Cause I'm crying and I'm just high blood pressure. And so, yeah, we'll give you, try you on a low dose. So I took it, right? Nobody told me that antidepressants will knock you on your ass. So I'm at work and I feel like I have never slept ever in life. I was yawning. I was nodding on my desk, on my keyboard. So they had like a little sofa in the ladies' room that you can go in and take, a little power nap or whatever. I'm like, yeah, I'm gonna try and take me a little nappy nap, and because I can't keep my eyes open. I'm gonna get in trouble. Oh man, it was so rough. And so one of my coworkers I talked to, she was on antidepressants and like she was on a lot of stuff. And so I was like, so tell me, like, is this supposed to? I guess it's supposed to make you sleepy. I said, how long does this last? She said, oh, it won't take long. You'll get used to it in about a month. I said, a month? I said, oh no, I will just be anxious. This is not for me. Nope. And then when I took it, I'd get sleep paralysis. So it would feel like I was being bound. I was being, hugged really tight and I couldn't move. The Xanax was not for me. That was not a good solution. Not a good solution at all. So the best day of my life was when she sent us both out the door. She sent us both out the door. Oh man, it was such a wonderful experience. But like I said, Office Space, after I worked there, it made all the sense in the world. And it becomes more and more relatable as the older I get. There were days that I wanted to take the copier and take it out in the field and beat it. Plenty of days I wanted to beat the copy machine. Yes. Playing rap music on the ride there, getting myself mentally prepared for the bullshit that's about to occur. Getting the email saying, make sure that you're only speaking. The only things that y'all should be saying is good morning and good afternoon. I shouldn't hear your music out of your headphones when I walk by, and I don't even want to hear your foot tapping on the carpet. That's a real email. That's a real email. And then they had the thermostat on Arctic Circle because, everybody was going through menopause. So I had, some experiences at that place. Shirley, if she had brought us a veggie tray one day, she sent us an email about, I got some fruit tray and a veggie tray that I brought in, help yourself, blah, blah, blah. So I'm like, okay, yeah, I'll go and get me some carrots and the fruit and veggie tray. Yes. I wasn't doing the Dunkin' Donuts and stuff with y'all, but yes, I would do the tray. Yes. Oh, hey, Munchkin, I didn't know you was in here. So the few of us who does not eat crap all day had our little, carrot in our dressing, a little bit of light ranch, and we was having a good time. Then one person's stomach starts to hurt. Dana sat next to me to my right. Then her stomach starts to hurt. Then my stomach starts to hurt. Then the other girl who was next to me, her stomach starts to hurt. And we're all taking rotating trips to the bathroom. And what did we find out about that tray? What did we find out about that fruit tray that she so graciously brought to her team? That her son got married over the weekend, right? And so the leftovers of her son's wedding, she brought into work on Monday. Either Monday, it may have even been Tuesday. It was too long. So, you have a wedding and food is out. And food is out a long time. Too long for a fruit and veggie tray. So then it's been out all day, been breathed on and everything. Then you've either taken the tray home with you, so it's been in your car. We don't know what temperature your car is, but it's been in your car, in your trunk. You bring it in the house. You probably laid it on the countertop for a while and then thought, oh, I know how to get rid of this. I'll take this to work on Tuesday. And then you put it in the fridge. So yeah, that could cause somebody's stomach hurting and having some gastronomical having some gastronomical issues. You're having plenty of gastronomical issues. And so they said that she felt bad that she made us all sick. We didn't get no apology, though. She didn't say, I apologize for making y'all sick, bringing y'all my son's leftovers that I was too lazy and too cheap to throw away. I thought I was going to bring it to y'all. I thought we was starting on a good foot because I think it was after New Year's. I thought we were starting out right. New year, new me. And then she come with that mess. She come with that mess. But office space, yes. Having multiple managers telling you the same thing in rapid succession, that Shirley told me something. And then her stooge will come by and repeat exactly what she just said. And I've gotten an email about it. Same thing. I'm like, yes, I relate to this. Yes, I would love to be able to hack the mainframe at work and hack the mainframe at work and steal money from the credit union. That would be great. That would be a wonderful dream. And it was, we was all like the me and the Spice Girls. We were like the little group of friends, and remember the guy, what's his name? Ahmed Ahmadinejad. Samir. No. Michael Bolton. And they go, oh, is that your real name? Well, I get that all the time. I tell them my name, Miracle. So that mean that you're a miracle? Were you a miracle? I know there's a story about that name. Is that your real name? So I was there. I got it. The Michael Bolton one. Yes. I said, my life, every day, my life. Yes. I said the boring parties, the layoffs, There was a person that was sort of like the little jump to conclusions person. What are you doing, Munchkin? The jump to conclusions guy. And there was the little slut dude, y'all sure my old face. Oh. We have some of them. Those were the cool people. But all the annoying, stupid people, yeah, that was real. Office space was real. It was real. It was so real. So that was the movie I revisited when I thought it was trash. I revisited Office Space. And I love it. Love it. Love it. But thankfully, I don't deal with those problems. Well, I guess I kind of do, but not as bad. I have more layers and more buffers than I had when I was at the place. But I did like to do database editing. That was pretty fun. It was just, put my headphones on, didn't have to really talk to anybody. I did have to call to verify rates for publications. I had some dude from New York get smart with me. Like, I don't know who this is and why are you calling me? I'm like, listen, like, you a publisher, y'all got some rates that we're billing for. We're trying to send you a check. What we doing? Do you want it or don't you? I know you're not hungry. What do you want, Munchkin? Well, anyway, let me go ahead and get off here. I've been rambling and rambling. So anyway, I want to thank you all so much for coming and spending the evening with me. Again, I am going to come back sooner. I'm coming, Munchkin. I'm going to come back sooner than I did this time. So please bear with me. I'll be having some difficulties sometimes. Shut up, I'm coming. Let me say goodbye. Oh, I swear, it's like I'm his assistant. Anyway, thank you for all coming. Make sure you guys smash the like button if you haven't already. And if you haven't subscribed, please do so as well. I'm coming. Oh my goodness. Well, His Majesty awaits. Y'all have a wonderful rest of your night. And please.
Ladies and gentlemen, we have had a great time tonight. We have truly enjoyed ourselves. And we would like to thank you for being a part of the show and coming to visit this platform. Live on YouTube, Auntie Miracle